Your Honor, good morning. Matt DeVise on behalf of the appellant. May it please the court.
I'm sorry, give me your name again.
Matt DeVise.
Thank you.
Before I begin, the appellants would like to request 5 minutes for rebuttal. May I begin the argument?
Go right ahead.
Thank you. Again, Matt DeVise on behalf of the appellants.
Mr. DeVise, I'm sorry, can I interrupt you for a moment? I am having trouble with the clock.
Oh, no problem.
And I think my able deputy marshal is going to be able to fix this for me. I have technically challenged this morning. I'm sorry. Please continue.
Thank you. Matt DeVise on behalf of the appellants, James Armour, the Bayshore Road Trust, and 4449 Holdings. This case arises out of additional insured benefits and a declaratory judgment action brought by Mr. Armour against Owners Insurance Company. A brief factual background that relates to a high-end residential structure in Sarasota, Florida. The original construction was done for Howard Jacobs, and the general contractor was Boyd Building and Design. Boyd Building and Design entered into subcontracts with many subcontractors. The stucco company was one of those. Those subcontracts required the stucco company to name Howard Jacobs, the prior owner, and Boyd Building and Design as additional insureds under the respective policies of insurance. Where I'd like to begin with this particular argument is the undisputed fact that Owners Insurance Company was on notice of the claim for construction defects in October of 2000.
Are there any cases that say you're just on notice that there is a lawsuit and that's satisfactory?
So I would point the court to the Calora case. The Calora case is from this court in 1964, and it is what we have principally relied on. In that case, it was a garnishment proceeding between the insurer and the insured. There was a judgment entered. The insurer took the position that it was not obligated to cover the damages under the policy because the insured had violated the notice and duty to cooperate provisions of the policy.
Isn't that a little bit different from here? Because what boils down to this case is the issue of tendering the defense. We're dealing with an arbitration proceeding that apparently has taken place. And if I may, let me and it follows what Judge Atkinson is asking. In this case, by virtue of somebody having notice, it's far different from a demand to tender the defense. And in this case, and correct me if I'm wrong, I know you the whole argument in your brief, you make reference to the Baumann letter, but didn't the Baumann letter just simply, it was a demand made by Jacobs against TSC, correct?
It was a demand for defensive indemnity. It's the letter says we're demanding defensive indemnity.
Pursuant to, and based on what right to?
As an additional insured under the policy.
Okay, now where does that say? And help me out. Does the letter say anything to basically telling auto owners, we're making demand to you, and we're also making the demand that they are additional insured? Anything, because if there's anything in the record that mentions that the term, additional insured, a demand, tendering to tender the defense. Anything like that in the Baumann letter? Help me out, because I got it right here. There would be no point to send the letter to the insurance company if it was not a tender.
I thought we were talking about a letter going to the insured.
It went to both. Auto owners was copied.
Well, let's leave that aside. I think there's in the briefing, there's, for the sake of this argument, we're talking about the Baumann letter?
Correct.
Or the letter that you also allege was copied to?
The Baumann letter dated September 23rd, 2009. It's in the record at 135.
You're saying that letter went to the insurance company?
Correct. Auto owners was copied on that letter, and it's undisputed that auto owners received a copy of that letter on October 5th.
I interrupted. So you were saying to Judge Kazan that there would be no reason to send it to the insurance company if it wasn't go on with your point.
Correct. So Stucco Company was the insured. The letter came from counsel for Howard Jacobs. So clearly the demand had to come from someone that was claiming to be an additional insured, because Howard Jacobs was the owner of the structure. And presumably the stucco company and auto owners had the subcontract in their possession, or could have reached out to the stucco company to obtain the subcontract and say, I see section 7.1 of the subcontract, which clearly states the owner and the general contractor are required to be added as additional insureds under these policies of insurance.
I guess I'm having a hard time with that, because what you're trying to do is basically jump your argument that this initial letter somehow, which is a potential claim against Stacy, somehow you're making the allegation that now there's additional insured. And I know what you're saying here, but where in the letter does it really set forth, hey, these are additional insured. We want you to tender, to tender the defense. And just simply, and this goes back to Judge Astis, just simply copying someone with a notice is far different from the cases that say, hey, let us know what's going on. Give us either a copy of the pleading or let us know what we need to do in order for us to step in. Because when you look at how the facts of this case developed, the arbitration proceeding went on, and it was rather a huge amount of fees and costs generated from that. And so ultimately, was there prejudice? They seem to think that that's a lot of money expended, so there is prejudice. So I go back to the basic. Where in that letter, if you're referring to that letter, where does it say definitively, we are additional insured, we're demanding that you tender defense, as opposed to simply copying someone with notice of that?
So they use the express language demanding defense and indemnity, and it's sent directly to the insurance company. And I would still go back to the Calora case from this court, and I do not think that case is distinguishable. And the specific provision from that case is, and I'm reading from page 16 of the initial brief, the insurance company next contends that the record here shows that Stevens, the insured, violated the assistance and cooperation clause of the insurance policy. Our consideration of this point will encompass all of the facts and circumstances disclosed by the record, specifically including Stevens' failure to forward the suit papers to the insurance company. Even though we have previously rejected the contention that this fact alone constituted a breach of the contract as to relieve the company of liability, it is an element to be considered with reference to the cooperation clause. And it makes sense. When an insurance company gets a letter like that demanding defense and indemnity, the insurance company as well has an obligation to cooperate with the insured. And that's what the cases say under the duty to cooperate. If you look at Calora, if you look at Ramos versus Northwestern Mutual from the Florida Supreme Court.
I don't dispute that. But isn't there a distinction between cooperation, and you have to look at the language of the policy here. We're talking not just cooperation, we're talking if you're making a demand, and the criteria of the policy is you provide us with this, you give us notice, you tell us, you need to indicate all of that, which is different from a cooperation. And when I read Calora, it's a little bit different, because here you're making Armor is not part of the policy. You're taking the position that they are qualified as insured, which lends to the next step. How would owners be put on notice that, hey, we're making a claim for Armor, and we're asking on behalf of Armor, but yet it's directed to someone else? Do you see the problem that I'm having?
I do, and I would again direct your attention to Calora, because what you just said is directly addressed in Calora, and all of those policy provisions in the subject policies. Calora says that is an element to be considered with respect to the cooperation clause. So what owner's insurance company should have done upon receipt of the letter is engage in a good faith investigation to determine who really was the claimant, what was going on here. If you look at Jennifer Howard's deposition testimony, and she was the claims adjuster on behalf of Stucco, she sent 2 letters and made 1 telephone call and closed the file. How about going on Google, looking at the property, reaching out to any of the subcontractors on the project, actually engaging in— Didn't
she say, hey, can I get some more information if you—
She made 1 call, spoke to a paralegal at Mr. Bauman's office, then sent him a letter. The next day sent a letter to the Stucco company saying, we have been placed on notice of a claim for construction defects at the property, and then closed the file. So our brief—
So then the the party can wait all the way until $4 million in fees is done and sandbag the party who supposedly owed a duty to defend to an additional insured because they didn't get a call back, because they didn't call the insurance adjuster back?
There's no sandbagging here. It's on behalf of the insurance company to engage in a good faith investigation. So the testimony from their claims adjuster and relatively clear.
If you wanted us to reverse, we'd have to write an opinion. And what it sounds like I'm saying is, well, okay, a letter got to the insurance company, was copied to the insurance company, it was a letter to the insured. The adjuster, correct if I'm wrong, I might have the facts wrong. The adjuster calls back and says, hey, you want to give me information? Here's my contact information. And then those communications break down, for lack of a better way to describe it. And then arbitration happens, $4 million in fees later. Say, well, hey, you should have defended us. So is that the way the opinion should be written?
No, it should be written. It should start with the fundamental facts that October 5th of 2009, you can look at record page 8246, response to the plaintiff's third request for admissions. Owners admits it was on notice of a claim for construction defects. The letter says demanding defense and indemnity. It's written on behalf of Howard Jacobs. It copies auto owners. You should then go to the specific wording in Calora, which says, once the insurance carrier has notice, and if they're going to make the argument that they weren't provided a copy of the petition or complaint, that implicates the duty to cooperate. Then you should go to the realm.
If you're going to make reference to Calora in the opinion, didn't Calora, they also got a copy of the pleadings and a request to authorize defense of Calora, which we do not have here.
There was still an analysis under Calora.
Okay, because if you're making, and that's why I mean you're banking on Calora, but Calora factually was different from here.
Then the court could look to Ramos versus Northwestern Mutual from the Florida Supreme Court in 1976. The court could look to American versus Valet from the Florida Supreme Court in 1941.
And I appreciate all that, but it just doesn't, the problem I think that you have in your case is that you're banking and all that, but the bottom line is, when it came to the arbitration, and I just jumped to it, arbitration was never tendered to owners for defense, never.
So that is not quite correct and it's inconsistent with the record testimony. So if you look at record page 14123 and 14124, that is a letter from Ralph Rodriguez dated February 4, 2011, and he was the attorney for Howard Jacobs at the time. And he sent auto owners a letter enclosing the arbitration petition and the amended arbitration petition. The argument from owners is that there was a subpoena to FedEx, and it came back non-deliverable. We took the deposition of Ralph Rodriguez. The testimony is quoted on pages 4 through 6.
That's from him, but wasn't there evidence also too says there was a FedEx, something says it was not delivered. That was part of the record as well?
Correct, and that would be conflicting testimony for the jury to consider.
So you have a document from FedEx saying non-deliverable, then you have testimony from an individual saying, oh, I believe I directed my paralegal or someone to mail it or to FedEx it. So you have that testimony that I believe it was done. So there's no definitive testimony that I personally have done that. Then you have this document from FedEx saying not delivered. So I guess the bottom line is that going back to Judge Atkinson's case, that if you want us to write an opinion on this case, how can we write it based on this fact? It would go contrary to every single case that we've talked about in terms of putting the insurance company on notice of tendering a defense, providing copies of the pleading, and complying with the actual provisions of the policy itself that really delineates everything that needs to be done. That opinion would be almost like that we've gotten rogue, because it wouldn't be in support of all the cases that are in place.
It would not. It would be entirely consistent with the case law we have cited to you. You also have conflicting testimony that I just talked about for Mr. Rodriguez. I respectfully disagree with your characterization of Mr. Position. Again, that's quoted on page 4 through 6. You also have an affidavit that was sent from Alan Frederick, who was another attorney on behalf of Howard Jacobs. And he sent 2 letters directly to the stucco company demanding defense and indemnity as well. And that was after the issuance of a 558 notice of claim that was sent by Mr. Armour to Howard Jacobs in June of 2009. Those 2 letters are dated June 18th and June 9th, July 9th and August 18th of 2009. And again, Mr. Frederick submitted an affidavit in support of the submittal of those letters, the purpose of those letters being demanding defense and indemnity. If we go to the second issue on appeal, Armour contends the trial court erred in entering summary judgment based on outstanding discovery.
Mr. Devise, excuse me for interrupting, but you're up to about 15 minutes, so you're going to get to your rebuttal time, but use your time as you wish.
Okay, I'll reserve the rest of the time for rebuttal. Thank you.
Thank you.
Morning, may it please the court. My name is John Russell. I'm here on behalf of Owners Insurance Company with respect to this matter. The court's being asked to review whether or not the arguments asserted by appellants are sufficient to reverse the trial court's order granting summary judgment in favor of owners. The issue in the underlying case that was addressed in the underlying issue is whether or not there's a right of reimbursement for actually $14 million, not just $4 million, $14 million in attorney's fees incurred by both the plaintiff in the underlying action and Jacob. So they wanted both sides to be entitled to a defense. And what the arguments owners relied upon were a lack of coverage under the insuring agreement. There was no duty to defend, and also a prohibition under the policy saying there is no coverage for voluntary payments voluntarily made by an insured, or in this case, an alleged insured, without the consent and permission of owners. The arguments being put forth by the appellants is essentially contrary to what was argued and what was ruled upon by the judge. They don't actually address the voluntary payments. They don't address the lack of a duty to defend. They don't address the basis for the court's ruling. Instead, they try and recharacterize the issues into a lack of cooperation.
If we decide that there was a dispute of fact about whether the Rodriguez letter was in fact copied and successfully delivered to owners, is that a material issue of fact?
The content of that letter, yes, it could be. But let me make very clear as to whether or not the issue is a material fact. First off, Mr. Rodriguez testified that he believed he got sent. He didn't send it. It wasn't his assistant that was deposed. And the assertion or characterization as this being undeliverable, no, that is not the case. What happened here was it was never sent. FedEx got a subpoena for all the documents sent to these addresses by this law firm for a period of 2 weeks. It wasn't sent and not delivered. It was never sent. And so the characterization that somehow this was just not delivered is not a fair characterization at all. And Mr. Rodriguez's testimony was paid for by Armour. He was prepared by counsel for Armour, and Armour was the one who did the subpoena in the first place to FedEx, trying to verify that this was delivered, only to find out it wasn't. And yet they never told Rodriguez that the letter was never sent or delivered. And so when he testified, he said, "No one told me it wasn't sent." He believed it was sent. That is not testimony that could possibly create a fact issue. And Jennifer Howard's testimony and affidavit clearly say that we never received any such tender, any such letter, any communications. So there was never any tender. And going back to the first letter, the Bauman letter.
Let's say, my question was, excuse me, if we were, for the sake of analysis, to decide that it is a fact issue, create a fact issue, does that fact, which is that issue, whether it got to the insurance company, is it a material fact? And if not, why not?
If they received something they didn't, I mean, they testified they didn't receive it. So I guess I'd have to.
My point is, does that win the day for Jacobs?
If Jacobs could, yeah, from the point of, hey, here's a tender, and I'd have to look at the exact language of what that letter was. The letter was to TSC. This letter was not.
Right, it was to TSC, and
TSC has never
sent it. I guess I'm asking you about its contents. I mean, does that constitute the requisite notice invoking the right as an additional insured for defense and indemnity from the
Yes,
insurance
I
company.
believe that content had something that said, send this to your insurance carrier for additional insurance coverage. So that was the first time that was mentioned. But again, that's in a letter that was never received by auto owners and was never sent to auto owners by the clear record evidence. The attempt to create a fact issue based on someone's belief that somebody would have sent it. All Mr. Rodriguez testified to was the fact that .cc means it should be sent or copied to another party. And it says CC FedEx. He believed it was sent that way. He didn't testify that he did. He didn't say he put it in a FedEx envelope. There can't be a creation of fact based on someone's belief that this would have occurred. And it's also important to note that this is not the only instance where alleged CCs were never sent via FedEx to all the parties. Numerous other insurers in the same action allegedly received CCs of letters sent by Mr. Rodriguez's firm, and many of them denied ever receiving them. So this is not a single occurrence. This never happened. So the fact
what we need to do actually, because in looking at this record, we have to see what's in the record itself and not make supposition about what they've wanted. So based on this record that's before us, which we are reviewing, is there any evidence, number one, that somehow this notice was sent? And I think that's really the analysis for us to determine for this record, you know, based on the record, not someone saying, oh, this is what I think and this is what I believe, but based on the record and the factual evidence before us. Is there anything in here that your client was told, these are additional insured, we have this arbitration going, you need to step in and provide a defense for us? Anything like that in the record before us?
Not a single document piece of that venture on it. Every single, the only time owners was ever made aware that these parties were going to claim to be additional insureds and entitled to recovery of all these fees and costs was when this action was filed. The record evidence has no testimony indicating owners ever received any of this, or that it was ever actually sent. Like I said, Mr. Rodriguez's belief is simply not evidence. And even if you were going under the mailbox rule, you would still have to have the person who actually submitted the document into the mail system and put it in the thing. Here we have a much better case because we have FedEx who can verify whether or not it was ever placed into the process of delivery. And FedEx has confirmed that that was not the case. So there is no evidence whatsoever that owners was ever made aware of a tender by any of these parties. And even Armor in this case has never alleged that Armor made them a tender. Going back to that first letter, the Bauman letter, that was a letter to TSC. That was a letter from a GC / owner saying, you're a sub, and if I'm liable, it's because of you. So I wanted a defense indemnity from you. That's what you would make to any party. That has nothing to do with AI coverage. Additional insurance not mentioned. In fact, they specifically referenced TSC as the insurer of, owners as the insurer of TSC, not the insurer for Jacobs. And it's also important, you know, they focus a lot on Calura. And the court's correct. The facts are completely different in Calura as was the language the court used in final holding. And it's an important distinction. In Calura, the plaintiff's attorney forwarded the suit papers and asked for a defense indemnity of the insured. So the insurer was on notice of it. In fact, it's very parallel with this case. We never received any request for defense indemnity on behalf of these parties in the arbitration from anyone. But you know what we did receive? TSC was defaulted. TSC was non-committed, so non-communicative with owners in any way. In the underlying subcontractor action, they were sued by Mr. DeVise's client, Armor, and they were defaulted. So what happens? Armor wants to make sure that TSC has coverage available to respond to any resulting verdict. So they tender that action, the action by Armor against TSC, to owners. They send a complaint and say your insurance has been sued and is defaulted. So what does owners do? They review it and they pick up the defense of TSC. They litigate it, they defend it, and obtain a recovery. Obtain a verdict in favor of TSC saying no liability whatsoever. Years later, so they know how to tender a defense. They know how to ask for a defense of a complaint alleging to be additional insurance on behalf of themselves and on behalf of others. They chose not to do it. Jacobs knew how to tender a defense to an insurer and ask for recovery. They got into a coverage dispute with both insurers, the two insurers whose claims are assigned to Armor in this action. They were involved in a coverage dispute as to whether they owed a defense to Jacobs. They litigated it and they came to a resolution and they assumed the defense. So all these parties are certainly aware of how to do it. And the Embroidme case, which is directly on point, it's addressing the issue of whether or not you have recovery rights for attorney's fees and costs that are incurred prior to a tender in this action. And as the Embroidme court noted, the insured in that action was not unsophisticated. The alleged insureds in this action are clearly not unsophisticated. They know how to do it. They proved they knew how to do it. And owners, when notified properly of a tender, assumed the defense of TSC, defended and obtained a verdict in their favor. So the argument that somehow that it's owner's fault that this wasn't reviewed for coverage and determination of defense is nonsense. It's also important to note the court relied only on the lack of tender, the request for reimbursement of fees for the basis for the ruling, but owners also took the position that they're not insureds, that there is no covered cause of action, and there are other bases for ruling against coverage in the first instance. The court simply ruled on this because it was the easiest and most straightforward issue. And that's why a tender is very important, because an insurance company has to realize and determine whether or not the parties claiming to be entitled to defense are in fact additional insureds and review it and determine it. And you certainly can't get that from the Baumann letter, which not only doesn't address any of that, doesn't talk about additional insured coverage, but is months before any litigation. So the argument that that letter can somehow constitute a tender, when it doesn't reference a tender, doesn't reference the defense of an ongoing proceeding because it didn't exist, that simply isn't the case. And the Hamid case also talks about the fact that notice of a potential claim is not nearly sufficient to satisfy the obligation to tender a defense of a lawsuit once it's filed. They never did any of that. I know the council didn't get a chance to discuss the discovery issues, but the argument that the summary judgment should have been postponed yet again for discovery issues is without merit. There's a few issues there. First, they're again seeking claims notes. If this court will recall, we've been here before. They asked for the claims notes and sought that information. This court said you can ask. You can take depositions of owners' representatives on issues of notice and tender and go into those issues. Those depositions did in fact take place. Jennifer Howard was deposed, as was a corporate representative of auto owners. They had that deposition. In that deposition, they did not ask either party, when were you aware of the arbitration proceeding and did you ever get copies from any source of arbitration pleadings? Not that that would have mattered, but they never asked those questions. Now they're asking this court to revisit its ruling that it's that they're not entitled to claims notes, to say that they need to review those documents to see if we were on notice of a proceeding and had ever received pleadings. When you don't take the opportunity when provided at a deposition, you certainly then don't give yourself the opportunity to invade the privilege of another party in claims notes or have a rehearing on this court's determination that the claims notes are not appropriate. The other issue they were trying to allege is they wanted to ask defense counsel about those same issues as to owners' knowledge of the arbitration. Again, if you don't ask owners' representatives the questions, there's no reason to say, let's ask a third party what owners knew about. It doesn't make any sense. And more to the point, the only reason those depositions didn't take place was because they canceled. It was their own volition. It appears that the discovery issues were simply an attempt to postpone the summary judgment yet again so that owners couldn't move forward and we would be forced to go to a trial without conclusion. Your Honor, again, the other issue they've raised, and it's somewhat unusual, is saying every single issue that we raise, every single issue in any kind of coverage dispute is somehow a condition precedent to suit that you have to raise, pre-suit, and if you don't do it appropriately, somehow you've waived everything. We've addressed that issue in depth in the briefing. It doesn't have merit. There's no basis in the law for saying every single argument is a condition precedent. And even if they tried to argue that somehow any of these were, There's no basis for arguing that there's somehow prejudice because the Supreme Court has noted that even in the conditions precedent, you do not have a waiver in the event that there's no prejudice. And the prejudice that they talk about with respect to legal malpractice cases or 558 notices or anything like that is where there is a failure to notify the plaintiff of a condition precedent. They then have an expiration of, let's say, a statute of limitations or something else that detrimentally impacts the ability of the plaintiff to move forward on the case. This court has recognized the analysis in Ingersoll as a waiver analysis, and there's simply no basis for arguing either that these are conditions precedent or that they are somehow subject to waiver. And again, with the argument of cooperation, we didn't raise the cooperation. We raised the fact that it's not a duty to defend. We didn't breach the duty to defend, and voluntary payments simply aren't covered. Trying to recharacterize that into cooperation doesn't make any sense. Essentially, what they're trying to say is, in addition to everything you allege we breached under a policy, we also breached the cooperation clause, or we also breached the no sue clause. That doesn't make a whole lot of sense, but it's a little like a criminal saying, you charge me with this crime, but I'm also guilty of this crime, and I want you to only prosecute me under that because I have a better argument. We are going under the arguments we made in the motion for summary judgment, which the court, trial court ruled upon. The fact that they want to contend that they also violated other provisions of the policy doesn't change that, and neither of those other provisions that they're citing somehow subsume or overwhelm the other issues in the policy. We believe that the trial court's order was eminently correct. We request that the court affirm, and the court doesn't have any further questions about the rest.
Thank you, Mr. Advise 5 minutes to respond.
Quickly on the Bauman letter, I'm just going to read what it actually says. This is to advise that we are your commercial general liability insurance. Sorry, it says, on behalf of Howard Jacobs, we are hereby tendering defense and indemnity of this matter to you as the insurance company on one of our clients' subcontractors, the Stucco Company, Inc. You have 15 days to accept defense and indemnity as an additional insured under the policies issued to the Stucco Company. A few other issues. He said that there was no suit at the time the Bauman letter was sent. That's part of Alan Frederick's letter. There was a 558 notice of claim attached to those letters. The Florida Supreme Court's analysis in Altman Contractors in 2017 says a 558 notice in the repair process under that statute constitutes a suit under a commercial general liability policy. The Embroidery case is entirely distinguishable. In that case, there was an 18-month period with no notice to the carrier. That's not what you have here. You have undisputed record evidence that owners was on notice of a claim for construction defects. Going to the other two issues subject to the appeal, the first is the pending discovery. So the argument that we were not diligent about taking the discovery is inconsistent with what owners told the trial court. They told the trial court we were harassing them in terms of the discovery that we were seeking. They are mischaracterizing this court's opinion in the prior interlocutory appeal. In that case, this court cited to the Freeland case, which was a dispute over the ownership of an aircraft. And the court was very clear, and Judge LaRose and Kuzan were on the panel for that decision. The court cited to Freeland and said, there is no categorical rule that claims notes or claims file in a coverage action are prohibited from discovery. I would point the court to this court's opinion in Progressive versus Herzog 2020 case. In footnote 2, the court went as so far to say, and use the word obviously, that does not mean that every document or material an insurance company elects to place within a file labeled as claim file constitute work product. An insurer may request that the trial court conduct an in-camera inspection of the withheld documents to ensure that each properly meets the specific criteria of the work product and or attorney-client privilege. So we were relentless in the trial court about trying to obtain the claims notes. The reason those are important is, again, back to Calora, and we've cited a bunch of other cases on page 36 of the initial brief that stand for the proposition that if the insurance company gets the pleading, the petition, the complaint from any source, it cannot be held to complain. So there was a separate circuit court litigation going on against the stucco company. They hired a lawyer named Jim Price to defend the stucco company. He was actively attending depositions in the construction defect litigation where the arbitration was being referenced. Clearly, he could have sent an update to Jennifer Howard saying, here's the arbitration petition, and that would be an issue of fact under Calora and the related case law. And Armour had the right under the procedural rules for the court to conduct an in-camera inspection of those documents to make that determination. Owner's position is, I say it's work product, it's final work product, and you're done. That is not the law. Under Florida law, there's a recent case from the First District in Peoples-Jones versus Foster. We filed a notice of supplemental authority explaining that there is no categorical prohibition on claims notes or claims file material in a coverage action. You get to the third argument in the appeal, the condition precedent argument. There's two primary cases, Saavedra and Scheck. Scheck is from this court in 2017. Saavedra was from February 19th of 2021 from the 5th District. Saavedra is directly on point. And in that case, the trial court entered summary judgment in favor of the insurer. The insured said the insurer failed to deny compliance with conditions precedent with specificity and particularity. The 5th District Court of Appeal reverses the entry of summary judgment. And in that case, the trial court ruled summary judgment was appropriate because the insurer failed to raise the deficiencies of the insurer.
Do you recognize the distinction between a condition precedent to filing suit and a condition precedent, say, to coverage?
Thank you. I'm very glad you brought that up.
And what is the rule required to be pled? Conditions precedent to suit or condition precedent to coverage or to some contractual right?
Conditions precedent to suit, and there is a factual mischaracterization in the summary judgment order that relates directly to that issue. It's record page 18966. The trial court tried to distinguish those two cases by claiming those cases relied on policy language that stated there was a condition precedent to suit. Essentially, all coverage or all conditions of the policy had to be met prior to coverage. And then the trial court says there's no such language in these policies. That is not correct. It's record page 9398, 9610, and 9825. There's three policies. Those are the 3 pages of the 3 policies. The very next sentence of the stucco policies, after the provision quoted in the summary judgment order, says, no person or organization has a right under this coverage part to sue us on this coverage part unless all of its
Since
terms.
the opposing party's not going to be able to respond to that, why don't you respond to their argument they put in their brief about the fact that's an inapposite provision?
It's not. It's directly on point. The express language says you cannot sue us unless you comply with all the coverage provisions.
So that goes into their argument, which is that everything's is a condition precedent to sue.
So our argument in the brief is duty to cooperate in these related provisions.
How can you avoid that result, that logical conclusion, taken to its logical conclusion?
They're either
when that provision is an insurance contract, every single defense to coverage has to be pled as an affirmative defense or pled, because hey, it says you got to comply with the policy, so therefore everything's is a condition precedent to suit, right?
They're either conditions precedent or conditions subsequent. So on the duty to cooperate, you have the Macias case, the Coran case from Florida Supreme Court in 2014 that says the duty to cooperate is a condition subsequent. You also have 2 cases from the 4th District Court of Appeal that seem to apply their conditions precedent. Either way, owners is out of luck. To me, it's an academic discussion.
You're just trying to mitigate my reductio ad absurdum argument to say some things might not be a condition precedent to suit, but
if they're conditions precedent, they violated the rule indisputably. If they're conditions subsequent, pursuant to Coran, they have an obligation to assert them as affirmative defenses. They did not. That's undisputed. We filed a motion to strike their affirmative defenses on October 23rd, 2020, a little bit less than 6 months before the summary judgment hearing, alerting them to these deficiencies. They did not move to amend. All their briefing says, and under Ingersoll in the Florida Supreme Court, it says You can amend pleadings liberally, but they never moved to amend. They had the option.
I guess to follow Judge Atkinson, the bottom line is, if you breach the policy requirements, then now you're making the argument, well, there's this condition, precedent to sue. It doesn't negate the fact that, hey, you're dealing with the policy requirements that your clients failed to comply. That, for me, is really the bottom line.
So there would still be an obligation on behalf of owners to comply with the procedural rules. And that's what Saavedra says, that's what Sheikh says, check from this court. And there was no material failure to comply with the insurance policy, and there was pending discovery at the time the order was entered, and ARMOR should have been entitled to pursue.
And with that, Mr. Devise, you have to wrap it up.
Thank you.
Thank you. Thank you. Our next case this morning is Ramsey versus East Hospital.